Any mention? Item number 1.
JP More. Yes.
Please, Your Lordship.
Yes.
This matter is
What
for,
matter about?
it's for admission today, my lord.
Okay. No, service matter.
My lord, actually, here, my lord, the father of the petitioner here, or appellant here, was an employee of a bank. So he died
Father of the petitioner.
Yes.
Appellant, sorry.
Appellant. He was a petitioner also. Initially, his mother was the petitioner. Then, after the death of his mother, during the pendency of the list, and he got substituted. So now he has come on appeal before your lordships. So his father was an employee of the bank, and he died in harness. So the bank had this in lieu of compassionate appointment, the bank had a scheme of giving payments, lump sum amounts.
In lieu of compassionate appointment.
In lieu of compassionate appointment. Okay. So the mother claimed that. So that went on, the litigation went on for quite some time. So finally it was, after the son had been substituted in the mother's place, so the mother has, the writ petition has been disallowed, not allowed. So we are on appeal before your lordship.
What grounds is allowed? What challenge? What grounds? Are you saying that this bank has a scheme, compassionate appointment scheme? Either compassionate appointment or some lump sum grant?
No, my lord. Compassionate appointment has been done away with.
Okay, they don't have a scheme anymore.
Lump sum grant.
Sort of
yes, yes, in place of that. Okay. So, my lord, the calculations which has been done by the bank, my lord, we are aggrieved by that, which has not been interfered. Yes, my lord. Okay,
let's see where
the entitlements, the calculations for the entitlements. My lord, the copy of the judgment is at page 162. Okay. It effectively starts from 163.
Excuse me. 163, yes.
63.
Yes.
This is the second round of litigation between the parties revolving around the same issue, that is the claim of the petitioner since deceased, now represented by his legal heir, the present petitioner. Such claim being for payment of ex gratia relief in lieu of compassionate appointment, which is due and payable by the respondents number 2 to 7 respectively. The brief story of the case is that the husband of the deceased origin...
1 second, sorry to interrupt. Now, second round litigation. What are the orders in the first round of litigation?
In the first round of litigation, Millard, that was this Honorable High Court interfered. The calculation which was done...
that time calculation was the subject matter in question?
That time also it was in question, and that was interfered with, and the bank was directed to redo the calculations on the basis of the findings of the Honorable Court. At that time, Millard, there is a limit. That means the entitlement for this ex gratia payment, Millard, for that the income of the claimant should be less than 60% of the last pay drawn. So that is where everything is revolving.
Okay.
That 60%, whether it is below 60% or above 60%.
What does the judge say?
In the first round of litigation, Millard, when calculating the income of the claimant, the son's income was also included. So that was challenged, and it was found to be more than 60%, and it was denied. So that was challenged before the Honorable High Court, and this Honorable High Court held that the son's income should not be taken into consideration. And then it was sent back to the bank for redoing the calculation. Now, that was redone by the bank, Miller, and this time what happened, the bank included the pensions which the claimant had been receiving from the bank as well as the earlier employers of the deceased husband, that is the army. From there, the claimant has been receiving some payments, some pensions. Now, Miller, the question which arose before the Honorable Single Judge is that whether those pensions would have to be taken into consideration or not. Our submissions before the Honorable Single Judge is that the payment, the income for the purpose of calculating whether it is below 60% or not, that has to be calculated as on the day of the demise of the deceased employee. Now, on the day of the demise...
That means, I understand, we understand, I think you see that you can't factor in the pension payments that is due to be part of the last pay drawn of the...
yeah, because at that point of time, there was no pension.
Okay.
There was no pension. This is the issue before your Lordship.
Yes, Mr. Bora.
No.
Lordship, this is a second round of litigation. In the first round, what happened? The decease expired in 2001. Now this scheme comes into effect from 2007. Now, as a goodwill, even in 2010, we gave a chance to apply under this scheme. Otherwise, they are not qualified to apply also. Now, in 2011, they did not apply in the right format. We gave another chance. Then their claim was rejected in 11. Then they came in 2012 for the first round. Lordship will get the order at page 110. In the first round, the same petitioner who is substituted now, he has claimed in that order that he is a non-dependent. At para 5, Lordship would see that I am a non-dependent. 110, Lordship would see the order.
Yes.
Para 7. A reading of clause 5 shows that a family includes only dependent children. Therefore, it may not be appropriate in the view to take into account the income of a non-dependent to compute the family income for the purpose of the ex gratia under the so-and-so. 3,000 earned by non-dependent son Bidyut Das is included. Now, the same Bidyut Das has come as a substituted petitioner. Now he is apparently a non-dependent, firstly. Secondly, the essence of this scheme, Lordship would find the scheme also at page 106.
It's to try to emergency, it's to 106.
Yes.
Whatever, yes.
Yes. The essence of the scheme was that the essence of any compassionate appointment.
Where were you reading? Where's the scheme?
Scheme, page 126, sorry, Lordship, 126.
Yes.
Lordship, the essence of any scheme is to tide over the crisis firstly, and to earn sustain the livelihood. Now the deceased has died in 2001. Now, first round of litigation ended in 2007. Now the second round is in 2018. Therefore, the whole object will be frustrated if such an petitioner is allowed. Secondly, Lordship would find that what I find in the first round of application, whether we calculate or not is a different thing. But it's their bounden duty to show the income in the application itself. In the first application, Lordship would see at page 73. In the first application, they did not show the pension from defense. Page 71, 72 is the application which starts. Lordship would see page 74.
Yes.
G, monthly income.
Yes.
We act on their application. Now, Lordship would see all incomes is shown as nil, and monthly income of the dependent family members 3,000, and any other monthly income, Lordship would see at G, last G Roman 5, any other monthly income is shown as nil. Therefore, in the first round itself, they have suppressed the income from the defense pension. They had to show it. Therefore, in the application itself, they have suppressed the vital fact which was later came to be known when we inquired to the UBI bank. They were receiving from the UBI pension from. Therefore, and moreover, the main mother wife has already expired. Now the present petitioner has himself claimed to be a non-dependent in the last order. Therefore, there is nothing wrong in the order of the single judge. Therefore, Lordship, and the ground, Lordship would see at page 21 of the order. At page 169, Lordship, 169 para 21. They have not denied the incomes. Therefore, that is, the order is based on their pleadings. May I read, Lordship? From the pleadings of the parties, the fact that the last drawn salary of the deceased employee was 6661, and also the fact that the monthly income of the petitioner from all sources is 6371 has not been disputed by the petitioner, as the above details have been brought on record by the respondent bank in the additional affidavit filed on 1611, a rejoinder to the same not having been filed by the petitioner. A copy of the revised ex gratia amount in lieu of the appointment of the compassionate ground and appointment of defendant of deceased employee on compassionate ground conveyed by the respondent bank through communication dated so and so. Annex as Annexure 32 of this, which goes to show that the petitioner is aware of the scheme. On perusal of the contents of the scheme, the relevant portion wherein is found details of eligibility criteria as Chapter 2, Clause 2. Lordship, the details are given there. Yes. Therefore, there is nothing wrong in the decision-making process. They have not questioned the decision-making process.
Yes, Mr. Chakravarti. You dispose it of, or you want another opportunity to argue?
But we may be given, Milord, an opportunity to place the whole case before your Lordship. Milord,
what? Give a fixed date on the next
Milord, the whole, what my friend has also not addressed, and the whole issue before your Lordship is that on which date the income of the dependent would have to be taken into consideration. That is the whole thing. The scheme says it is on the date of the demise.
We'll give you a date.
And the honorable single judge has not given a specific finding on that.
Yes, heard Mr. S. Chakravarti as a counsel assisted by so and so. Also, Mr. B. Bora, who is present on behalf of respondents number
227, Bank Lordship.
The main answering respondents
227.
That is 227. The matter admitted for hearing. Give a fixed date. We'll dispose next date.
Milord, if it can be the end of May, Milord.
End of May? Now you.
Milord,
yes.
I will be going out.
Yes, then list on so and so. Yes.
If it was the end of
you give it to yes.
End of it.
Item number 2.
Deeply applied.
Obliged.
Lord, item 2, I feel liberty to appear by video conferencing. Lord, I am appearing for the petitioner. Lord, this is a petition where an assessment, where a demand order against order under section 156 of the Income Tax Act was challenged.
Now let's see who's for the respondents here.
Yes.
Yes. Who's there?
Lordship, I am for the independent button.
Where are you?
Yeah, will you allow us 3 weeks time to file our response, Lordship?
Yes.
That's not yet received, Lordship.
Lord, I have some difficulty. I have no problem. My friend can take time again. Your Lordship said, give him time. He can take more time to file reply. But today, why I need to trouble your Lordships is, in fact, we also filed an application this morning. It should have ideally been numbered already. But my colleague who is physically present in the court will hand over a copy.
With the permission of the court, what application is this?
But I'll point out.
No, what applications?
Lordship, we have filed it. We have filed it.
No,
But we have not received any copy, Lordship.
In any case, one minute. Your Lordships, while issuing notice, had protected us by saying no coercive steps. Your Lordships issued notice on 27th February, then continued the interim order. But the difficulty is not that my bank accounts are still frozen. I'm not able to conduct any business. I'm not able to withdraw any money, even sustenance funds. Nothing I'm being able to do. Therefore, even though this prayer for defreezing my bank accounts is part of my main writ petition, part of the main stay application that I filed along with my writ, however, by abundant caution, I filed another application which my friend is saying he doesn't have a copy. I'm only saying, let them defreeze my accounts.
Take it up. One thing you do, Mr. Nair, right?
Please, yes.
You just get your local colleague to, your local counsel to serve a copy of the application. We'll take consideration next week.
But I'm only saying this. This application was by way of abundant caution.
No, whatever it is, once an application is filed, it stands to reason that they have to have, a copy of that in their hand at least.
This prayer is the same. It's also part
Doesn't
of my
matter.
business
Yes,
application.
what application is that? Is that come before the court? Mr.
It's the same.
A. Nair,
That's what I was.
the Senior Counsel behalf the petitioner submits that by way of abundant caution, a fresh application has been filed seeking appropriate interim orders, inasmuch as the bank accounts of the petitioner are not operable, as they still stand frozen. Stop. Next one, Mr. J.P. More appearing for the respondents number 2 to 4. Apart from seeking further time for affidavit, has submitted that a copy of the application is yet to be made over to him. Step in consideration thereof, this is matter after 1 week for consideration of the interim prayer. It is expected by the next date the affidavit of the respondents also should be on board. This accordingly also.
Yes. Can I request for Friday, my lord, if your lordship would be kind enough to accommodate me?
Friday is too short. We'll have it next week after 1 week. That is next Tuesday. Yes.
Item number 4 is the same matter, Lordship, same petitioner, Lordship, same prayer.
Yes, go ahead.
Connected, ma'am.
Yes.
Okay.
Item number 3.
May it please your Lordship. Lordship, in this matter, I'm praying for some more time, your Lordship.
Yes. What is the problem?
Your Lordship,
What's the problem?
Your Lordship, we're still awaiting instruction from the department,
Then?
your Lordship.
What to do?
Lordship.
What is this file?
The petitioner filed refund application before the refund.
No, when was it filed? Date. Date of filing of the application. February. Now February now is in April. You have not filed affidavit.
Your Lordship, it was.
When was the application filed? Not what is the matter about?
Your Lordship, on the 4th of March, Lordship, the matter came up for motion, Your
Yes.
Lordship. And this is the second time I'm praying for filing of an affidavit, Your
No
Lordship.
objection?
No.
Any interim orders operating? No.
No, Your Lordship.
Yes, Ms. R. Gurung, please, Vice Dr. N. Mosika, please phone the Lord further. How much time? 2 weeks?
3 weeks, Your Lordship.
3 weeks time. Expected next year the affidavit should be on board, yes.
Highly obliged, Lordships.
Hearing. Item number 5.
Wait, please, Lordship. Lordship, here I'm praying for some time, Lordship. Arguing.
Respondents, last time nobody appeared. Who's paying for respondents? This matter.
I believe Mr. Chetia from Guwahati, Lordship.
He is also not here. No prayer on his behalf.
Mr. Sharma,
also.
Lordship. I'm sorry, Mr.
Who
Sharma.
is Mr. Sharma?
Our local counsel is Miss R. Colony, Lordship.
Oh, okay. Last time he was in bereavement.
Lordship.
Okay. When?
2 weeks, Lordship.
Yes. MSR Colony. Mr. Sharma, he's available today.
No, my lord. On the last occasion, we
He's still in bereavement.
my lord, yes.
Yes, on the prayer of the parties, this has mattered for 2 weeks. Yes.
Most obliged, Lordship.
Item number 6.
The principle involved in this case, my lord, is for the equal pay for the equal work, my lord. This is a MEACL. So my time is to reply today, my lord. The
Reply to what?
Reply to the full-length submissions on behalf of the appellant, my lord. Senior advocate Mr. Amit Kumar has argued his full-length, my lord. Now it's my time to reply, my lord. So, my lord, first of all, my lord, before going to to counter, my lord, to the submissions made by the appellants, my lord, I'd like to bring certain key facts, my lord. What actually was pleaded in my writ petition. The first point that was pleaded in the writ petition is, my lord, that we are the members of the union, my lord. There's a MECL, Progressive Workers Union.
Yes.
And our members have been appointed on a sanction post, my lord.
Yes.
Sanction posts which are also available in a regular cadre, my lord. That was a point, the first point, my lord. And the second point that we have advanced in our petition was, my lord, the members have been serving in the temporary or a casual capacity, my lord, for over 2 decades, my lord. That is the second point that we have advanced, my lord. And the third point that we had advanced was, my lord, despite performing identical duties as regular employees in the same positions, my lord, when it comes to pay, we have been paid less, my lord. This was the third point that we have argued. And to that also, my lord, we have presented a comparative chart also, my lord, to show the disparity in the pay, my lord. That I will take, my lord, to that chart also, my lord. And also, my lord,
what about this first basic submission that was made last time? Is that clubbing or multiple?
Clubbing, yes, my lord. Yes, my lord.
I'll answer that first.
I'll answer that first, my lord. Now, my
lord,
we'll
come to your equal pay for equal work. First, we're clubbing your cause of actions into one single petition. Whether that petition will be sustainable. Yes.
Give me a second, my lord.
See, one thing which is last time was that what the petitions have done in one of the petition. Now also the question of one post, Mr. Yubin.
Yes,
the question of multitude of posts, right? Multitude of posts, multitude of what you say?
Yes.
Paid or being paid.
Yes,
it's on different grades and different before all across the different cadres. Correct.
My lord.
Now, what you have done is that you've clubbed this cause of action into one petition and you brought it before the court. Which so that is why we answer that first question as to whether.
My lord, in order to answer to these questions, my lord, clubbing of the multiple cause of actions, my lord, the Supreme Court has in many cases, my lord, allowed a clubbing of cause of action if the policy decision affects a common cause, my lord. Here, my lord, it's not a case where I am asking parity with the post, my lord, because this is what have been projected before, my lord. And nor I am asking for absorption of the post, my lord.
What do you mean by asking party of post? You're asking for the same pay and emoluments that...
Here the nature, what I'm saying here, my lord, what I'm saying here is the nature of the work, my lord. It's the nature of the work. So, for example, if I'm a Mali, my lord, what is my job? My job is to maintain the campus. So also, the Mali who is appointed in the regular employee, his job is also to maintain. So, for example, water pump. What is my job as a temporary employee, my lord? To operate the water pump.
That's your argument.
So that's my therefore this is my lord, saying that, my lord, you cannot club in a policy matter, my lord, the course of action, my lord. It's a very deceptive argument, my lord, to say the least, my lord.
Yes. See, the thing is that is your answer.
My lord, I have more answer to that, my lord.
The Mali does the same kind of work. If you're a plumber, fine.
My lord, I have...
Next point, huh?
My lord, So, my lord, I was just going through what is my, because I wanted to argue one after another, my lord, and that point also will come, my lord, which I'll try to satisfy, my lord, in more details in the later part.
That's a basic point. For if we fail there, that means there's no necessity for proceeding further. If the court satisfies that yes, it involves multiple cause of actions.
My lord,
There's no jury relationship between the petitioners themselves.
No, there's no question of there is no juror relationship, my lord. My lord, when we talk about the, just give me a second, my lord. I'll just. Because this, I have prepared my argument according to my this thing.
Should always be flexible. Shouldn't prepare it according to you can explain the question to the court.
My lord.
Because why this court asked this question? There's not a matter which we had taken up from NIPCO, I think.
My lord.
Same thing, but regarding the nature of duties, only different the hours. They're both doing the same things.
My lord.
In the grade 4, they were asking for equal pay. The
My lord.
decision was made because the hours are different. They serve in the morning, who serve in the evening.
My lord.
Even that constitutes a difference.
My lord, may I?
Part-time employment, yes.
My lord, may I? If my lord will be pleased to give me tomorrow, my lord, I'll answer to that. I have the answer, my lord, but I'm just not able to find out my notes. I have the answer, my lord.
Spell it out.
My lord. Just tomorrow, my lord, as a supplementary, my lord, if this bench sits or any available bench, my lord.
What to do? Mr. Archival General?
What about my friend?
Those who fight, run away, live to fight another day. So,
no, because now he has put his point very firmly, and I have to dig it out.
That is very
That you have
basic,
to dig
Mr.
it out,
Yogan.
and I have the answer, my lord. I'm equally confident I have the answer, and just because I got little disarrayed in that questions, my lord.
Sorry then. Yes. Mr. Yubin prayed some accommodation in order to bring up some authorities.
My lord.
To supplement to authorities list on so and so. You'll have to come with the next when the bench sits again.
My lord, I'm deeply obliged, my lord.
Grateful, my lord.
There's a problem using this because I'm not able to find the answer.
Next Monday, Tuesday.
Any mention?
May it please, Lordship. Lordship, I beg to mention item number 18, Lordship. Lordship, this matter may come up after 2 weeks, Lordship.
Why? Who's on our side? You ready?
So I've informed them, Lordship.
Not ready?
Since they are taking time, Lordship. To assess here, Lordship.
Good, 2 weeks.
2 weeks. Deeply obliged, Lordship.
5 years holiday should have been ready, yes.
Please, Your Lordship. Lordship, I'm praying for listing of pending matter, Your Lordship.
Listing of?
Pending matter, Your Lordship.
Which matter?
That CDPO, that service rule regarding service rule in the Department of Social Welfare, Your Lordship.
Listing of? I don't understand. You want upgrading?
Lordship.
Isn't the hearing list?
No, Your Lordship. It has not been, the matter is not, it's a pending matter, Your Lordship.
No, isn't the hearing list?
No, not today. Yes, Your Lordship.
I mean, that matter is already in the hearing list.
Yes, Your
It's on the
Lordship.
hearing list. When did it last come up?
The Lordship was supposed to come on the 15th, Your Lordship. 15th of this month.
No, when did it last come up? When was it last listed for hearing?
Lordship.
Should be ready with that. And what order was passed on that day? Did you
Lordship,
take time?
Lordship, we filed a miss case for stay, Your Lordship.
No. That day when the matter was last set for hearing, did you plead for time? Was it adjourned?
Lordship.
Then you don't do the hearing, then only with suits, lawyers do the hearing, they want to do it, then court can't work that way also. You have to cooperate also. If the case in the list, you try to do the hearing. Not you just adjourn it and then when you need something, then you mention it.
Lordship, the matter
Yes,
actually...
next week, yes. Yes. Yes.
On addressing this honourable court, Your Lordship, I beg to make a mention of an unlisted matter for tomorrow, Your Lordship, that is urgent and time constrained and requires your intervention, Your Lordship.
What's the matter about?
Your Lordship, my client is a medical officer, chief medical officer in Assam Rifles, and is very much aggrieved by the fact that he had tendered his resignation and it was rejected. Thereby, he also has to join his new workplace as the senior resident doctor in Nigrams, and they've given him time till the 26th of April to furnish all the mandatory documents. And
Where's the DSGI?
Your Lordship, I've just done the filing and it's processing.
Have you served a copy?
Yes, Your Lordship, on the 17th.
Tomorrow?
Yes, Your Lordship. Much obliged, Your Lordship.
Where's have they received copy?
Your Lordship, I've already attached it as an extra.
No, you serve it to them. They're standing.
I have no, not the standing counsel, Your Lordship. I had given to one of their juniors, Your Lordship, on the 17th itself. I'll give them a copy again, Your Lordship. Much obliged, Your Lordship.
Yes.
May I please, Your Lordship? Lordship, I beg to mention item number 17. Lordship, I pray for 3 more weeks, Lordship.
On whose behalf? On behalf of petitioner?
Yes, Lordship.
Yes, Mr. Hubert.
My lord, no objection, sir.
Yes. Yes.
Please, Your Lordship.
Yes.
Lordship, I'm making a mention on unlisted matter.
Unlisted matter?
Yeah, this is an urgency in the matter because...
Tomorrow?
Today itself, Your
What's the
Lordship.
matter about?
It's about, there's a dispute regarding Nokmaship in Garo Hills. So basically, we're seeking the intervention of the court for transferring of the matter from the pending court in Garo Hills, Your Lordship.
Tomorrow, not today. Why? What's the urgent for transfer of a case?
Lordship, the matter that is pending will be fixed tomorrow, actually. They're taking evidence tomorrow.
Evidence tomorrow?
Yes, Your Lordship.
Why do you want transfer?
Lordship, because this is the pending matter that is pending there in the CEM's court is supposed to be in appeal, and they're taking fresh evidence in that matter.
Nobody can take an appellate stage also. There's no hard and fast rule with the CM. He can take evidence. What is the matter? Why? What is the matter? Nokmaship dispute.
Nokmaship. There's a dispute in Nokmaship.
I don't understand. He can take fresh evidence.
Lordship, can
So
you
what do you want? You
the-
want this court to stop the taking evidence?
to just transfer the petition, Your Lordship,
To where?
to another jurisdiction, another
There's
court,
only
Your
one
Lordship.
CM.
I agree, Your Lordship, but
Then?
Lordship, kindly hear my senior, then he can.
Who's the
bring a
senior?
better- Casey got him.
Okay, it's already been filed.
Yes, yes, Your Lordship. It's in the
No, you bring it. Strange case, yes.
Okay, I'll leave that, Your Lordship.
Yes.
Item number 1.
Lordship,
You've received salary?
only for 2 months, Lordship.
How many months are you claiming?
Because till June 24, Lordship. Now the salary is only for 2 months, Lordship.
2 months means which months?
That is also not indicated by them because the utilization certificate has not been signed, Lordship.
Then we are getting nowhere.
Lordship, because the order says.
See, Mr. Dokrut last time said that he released his salary as received from the state government been released.
Lordship, she has not received because for the year 2024 she has not received any single penny, Lordship.
Your Lordship, may I submit the salary, whatever they have released before and put in the bank, that after the last order we have released that. Now new sanction came and the utility certificate not yet done to submit before the government. That one, it will be done soon after the sanction
give it to her
will be given.
also?
Yes,
We'll close it then, Mr. Nopir.
Lordship, because the salary...
No, but
we are ready to give.
The court that they receive the amount, they'll release the other amount also.
We are ready to give for
There's
that.
a question of willful
Lordship,
violation.
if there's an undertaking, Lordship, then...
There's no question of willful violation. Mr. P. Dokrut, Mr. M. Nopir today submits that 2 months salary has been received by the petitioner, but she's yet to receive
the remaining
the remaining amount. Stop. Like for Mr. P. Dokrut submits that whatever amounts that have been received from the state have been disbursed, and as fresh amounts been received, the amounts entitled will also be released to the petitioner. In his view of the matter, as there is no willful violation, contempt stands closed.
Much obliged.
Item number 2.
No, they in this writ petition they file an application for implement.
Implement of who filed?
Yes. But I have filed my objections.
The case has already become infructuous.
Lordship, not become infructuous. They're saying me infructuous.
What you are seeing?
I have filed an objection against the petitions.
See, the thing is that Mr. Qureshi, as per the last order, you made a prayer for disposal and mutation, correct?
Mutation, huh?
It's been disposed of since July 24.
Yes, so we filed an applications for mutation 2023, and the board has not taken any decisions.
No, they've said they've already disposed of.
No disposal, Lordship. There is not a disposal. Lordship, there is a cantonment. No, that is okay. That Lordship, can you see the kind of disposal?
12 July 2024, we have rejected the application. In my affidavit in opposition, Lordship, page 18, annexure 3.
I have updated for main case. In the main case?
Main case, affidavit in opposition.
Yes.
Page 18 to last, please. Annexure 3. Order dated 12 July 2024.
Yeah.
It is to inform you that no action for mutation of these whole right of holding number 4 JB, Southern transfer can be taken due to the following reason. You have rejected them.
See, then
Lordship, in this case, can you hear, Lordship? This because this is a cantonment board. It is not an individual letter issued by them, by the CEO. In fact, when the mutation application is filed, 2023, it is placed before the board. If they can show me any resolution of the board, I will withdraw it.
We'll close it.
No, Lordship.
They've given a letter C. Whatever it is,
letter,
because the reasons given here, Mr. Qureshi,
Lordship,
do not demand consideration by the board. If it's a question of mutation, which there's some question, now see, because the title suit's pending.
No, that is the ground they have taken.
Objection by so and so.
Yes.
About there's another objection by so and so by the applicant. So
for the ground they have taken, the title suit is pending. Lordship, I file my rejoinders. In my rejoinders, I have already enclosed, in the event of any mutation application is filed, they is to place before the board and they is to ask the person to get it published in the newspaper. Then they receive the objections. After receiving objections, the board members, they decides whether it to be considered or not to consider, because the mutation proceeding is a summary proceedings. But this is the letters issued 2024. I filed mutation in my rejoinder. I have stated what the illegality committed by them, because I need the decision of the board. I need the decision of the board. This board has to take a decisions. They have not, in my rejoinder, I have enclosed all those resolutions passed from time to time in connection with these mutation applications. This is the very different thing that when they came to know that I filed a writ petition, they issued one letter, backdated letter, and said, no, this cannot be considered because of the reasons.
Then you challenge this letter.
So, but
that means I challenge the letter. Then you withdraw this writ petition. You challenge this letter. If you agree with the letter, which is continued.
I'll make an amendment in my petitions.
No.
Because
where's your immediate petition? You won't allow this kind of,
Look, this is, Lordship, very surprisingly, this was never intimated to me. Only when filed a writ petitions.
Not intimated to you.
When the filed a writ petition, then only they came with the application that we have decided. So hurriedly. But whether they have followed the procedures of the mutation, Lordship knows the.
When the matter is taken up for consideration on the impleadment application of a certain Mr.
Ojasvi Gupta, Miss Ojasvi Gupta.
Mr. S.P. Manta, Leonard Senior Counsel, appearing on behalf of the respondent cantonment board, has submitted that the prayer made in the main writ petition, that is for mutation of holding number 4 J capital B in her name, has since been infructuous. Made in revision has been infructuous in view of the fact that the respondent, by letter dated
12/7/2024,
12/7/2024, has informed the writ petitioner that the mutation could not be taken up for the reasons stated therein. And although Mr. M.F. Qureshi has vehemently argued that the manner in which the letter has been issued is highly questionable, when in fact the application petition had been placed before the board, this court does not deem it fit the stage to
Lordship, only
entertain
the question is
matter.
that suppose
the repression is disposed of and close with the liberty of the petitioner to file afresh, if so advised. Yes.
Lordship may see that
the stands close along with Ms. Case was close. There's nothing. There's only prayer you made in the petition.
No,
Mr.
Lordship, the prayer is made. Lordship,
suppose
Lordship, I file application for mutations.
Doesn't
other
then you make
file
that,
objections.
Then you make that in your new writ petition. I'm not here in advisory capacity. You're asking for directions to direct them, amendments to issue them to do them, and you have rejected it. That ends there.
Yes.
All interim applications will stand disposed of this.
May I please, Your Lordship? Your Lordship, I'm praying for some time to file my rejoinder.
How many times you have prayed?
This is the first time, Your Lordship.
First time? Yes, MST Sunto. This was not for a 2 weeks time for rejoinder. This thereafter. Right.
Oh? Here also I'm praying for some time, Your Lordship, to file my rejoinder.
Who's the other side?
GHDC, Your Lordship.
2 weeks for the time. That's prayed.
Much obliged.
5.
Please, Lordship. Lordship, this matter, Lordship, I'm praying for 10 days time to obtain instructions, Lordship. Lordship, the petitioner here.
No, you're supposed to get instructions today, Mr.
Lordship, the petitioner is it's in maternal leave, Lordship. So we were unable to contact her, Lordship. Can you allow 10 days time, Lordship?
No, but only one thing, did she participate in inquiry?
Lordship, that's what, Lordship, we were supposed to get the instructions, Lordship.
I had enclosed the inquiry report, Lordship, in my affidavit.
No, that's he took time
Lordship.
last time. No, not him. Where's MSP Karma?
Lordship, she's on leave, Lordship.
Lordship, the inquiry report is annexed at page.
So what are we to do, Mr. Dakhar?
Lordship, I'm praying for 10 days time, Lordship.
Where we said it, Mr. Nompir?
Lordship, can you come to page 9, Lordship?
Oh, the affidavit?
Yes.
In the school premises?
Lordship. Lordship,
where's signature?
Appeared just below observer, Lordship. Observer Smiti Rinku Roy, 12/9/24. Appeared Smiti Shobha Gupta, 12/9/2024. Basically, she has to challenge his
She appeared, Lordship, but then whether the report was given to her, Lordship, that instructions were yet to obtain, Lordship.
She's aware of the report, Lordship.
Yes, Lordship. That's
See, but it becomes very difficult. We have to wait for 8 months.
No, Lordship.
When the matter can be taken up again? When can you appeal instructions?
Lordship, after 10 days, Lordship, hopefully, Lordship will try to.
Mr. D. Dakhar submits that due to the indisposition of the petitioner, instructions could not be obtained. This after 2 weeks is.
Some pleasure.
Item number 6.
Please, Lordship. Lordship, this matter is regarding regularization, Lordship. Some matters are there which will be listed on the 6th of next month. And
no, what's this one thing, Mr. Kharmi? We are expecting number 2. You want to find affidavit specifically for number 2. Have you filed it?
Yes, I have not filed, Lordship. Here, Lordship, the government, Lordship, the government will sit in a meeting. At the CS level, the government will sit in a meeting. So after the meeting, I'll get the instruction, Lordship.
Yes, Mr. H. Karmi submits that similar matters are listed on
the 6th of next month. This matter also may be listed together.
So he prays that this matter also be listed on the 6th of May and also to allow him to bring on board affidavit on behalf of number 2. It is allowed this on 6 May 2025.
Item 7.
May I please? I pay for the respondent up to 6 and pay for time to file affidavit.
You are appearing for the
respondent 1 to 6.
First appearance you making
yes,
today?
Yes, my first.
What is your name?
M.K. Majumdar.
N.K. Majumdar.
M for Madras.
N for M.K. Yes.
Your Lordship, for respondent number 7, I'll file the affidavit of service in the course of the day.
You are appearing for all 1 to 7?
1 to 6.
1 to 6, yes. 7 is Rajendra Trivedi. Okay. Mr. M.K. Majumdar, the counsel for respondent 1 to 6. Has appearance today on behalf of respondent 1 to 6. How much time require?
4 weeks.
4 weeks? No, we'll give you 3 weeks max. Yes.
I'm yet to receive a para comment. I'm yet to receive.
Doesn't matter. That's your lookout. 1 to 6 is allowed 3 weeks time to file an affidavit. Stop MS Marbo submits that. You'll file service affidavit.
Yes, Your Lordship, in the course of the day.
Submits that service affidavit with regard on number 7 will be filed in the course of the day. And list after 3 weeks, yes.
Item number 8.
Your Lordship, as per the last order, the respondent have
to file affidavit. For the state respondents 1 to 4, my lord. This, my lord, as per the order sheet, my lord, this matter is connected with 21. Item number 21 today. My lord.
Under petitioner and item number 21.
285.
My lord, in this particular matter, item number 8, my lord, as I submitted, we are supposed to file affidavit. Our affidavit was prepared, but in the meantime, an additional affidavit was filed on the 5th of March. So we have to take another instruction on that.
You file.
My lord, additional affidavit was filed with the petitioner.
Just Anwar Hussain, you file it means?
Yes, my lord.
Yes.
So, my lord, we have to take instruction
yes or
on
no?
that.
Yes, Your Lordship.
You don't know what you file affidavit or not? Yes, MS Arthoni submits that the affidavit is supposed to be filed in view of the additional affidavit filed by the writ petitioner for the times required. Accordingly, further 3 weeks time is allowed to the Respondents 124 to file affidavit. And what about you?
My lord, they are the petition and item number 21, which is connected.
Yes, this is matter together with.
And pleading is complete in that matter. My lord. Pleading is complete in item number 21.
This matter with the. Now we have to adjourn at 21 then. WC 285. Stop with it. Praise allowed, right? As it is submitted that, as the party submit that this matter is connected to WC number 285 or 2024, let the same appear after 3 weeks. Yes. This matter appear after 3 weeks, and the 285 after 3 weeks.
Item number 9.
Please, Lordship. Lordship, I have recently received the affidavit filed by the respondents. I'll be praying for some time to file my rejoinder.
You are?
I pray for some time, Your Lordship, to file my rejoinder. I'm the petitioner.
When did you file?
11. Lordship.
Yes, MSG Smarwa prays for allowed 2 weeks time to file rejoinder affidavit. This thereafter also.
Okay.
10.
Lordship, we have received the counter affidavit filed by the parties, Lordship, and we're yet to peruse the same, Lordship.
Speak clearly, loudly, yes.
Lordship, I'm praying for some time to peruse the affidavit which was filed by the.
To produce the affidavit filed by whom?
By the respondent state and headman, Lordship.
You want rejoinder?
No, the counter affidavit, Lordship. We have received just today morning, Lordship, the counter affidavit.
Yes, we have filed.
All of 5.
We have filed.
You are for 1 to 5. Yes. And Mr.
I'm
for 6.
6.
And you for? Okay, Mr. Tidakha submits that he has just received the affidavit filed by the respondent number?
Number 6.
Number 6.
6.
You want to file a rejoinder?
Also, I want to file a
rejoinder. He prays for 2 weeks time to file a rejoinder if necessary. Yes.
Obliged also.
11.
May I please, Your Lordship? I'm appearing for respondent number 4 and 5. We're supposed to file the affidavit. Some more time to file the affidavit, Lordship.
Your Lordship, it's been 4 times already, Lordship. That is sick.
How come it's PC Sama is very fast? Why is slow? Hiding something?
No, Lordship.
Then?
Some more time, like 2 weeks, Lordship.
What's the matter about Nokma?
Nokma matter, Lordship.
What about 1, 2, 3?
Same prayer, Your Lordship.
Same prayer means you're not filing affidavit?
Not yet, Your Lordship.
No.
No, Your Lordship.
You will file or you'll file?
You will file. We will file, Your Lordship. Positively on the next day, Your Lordship.
Yes. Respondents for 1, 2, 3 and for 4 and 5, pray for allowed 2 weeks for the time file affidavit. Expected next date.
Lordship,
Yeah, should be on
will
board.
continue.
Interim prayer, if any, interim order should continue till next day.
Item 12.
Yes, MS Shangwa's affidavit.
Your Lordship. Your Lordship.
File.
Yes, Your Lordship. In this matter, I prayed for 2 weeks' time, Your Lordship, to file the rejoinder.
Yes, 2 weeks time is prayed love for joinder. Yes, thereafter.
13.
There's a post in July.
Lordship, no, there is no more
Then
post.
what is good this poor fellow going to do?
Lordship,
he has to
let
join
them
the
file
post,
affidavit with Lordship with regards to this Sajar Lingdo and Mr. Therniang, Lordship. They're retired officer, Lordship, from Jawai. As far as my instruction.
Now,
instructions
officing appointees are there, Your Lordship. They have occupied, Your Lordship. He has to join, Lordship, till date, Your Lordship, from the date of the issue of the transfer order, he has not joined. And his whereabouts is not known, Your Lordship.
He's on next, Lordship, before Justice Lingdo would, Lordship. There's a part-heard matter, Lordship. He's conducting the hearing, Lordship.
It'll take long time.
Most probably, Lordship, because it's a second appeal, Lordship.
He'll post it tomorrow.
Lordship.
So this is matter tomorrow. Yes.
14.
In the supplementary list.
Your Lordship, I am for respondent number 5.
Yes.
Your Lordship, in this matter, I
Speak
prayed.
up louder.
Your Lordship, in this
Remember you're a
matter, I
lawyer.
prayed
Yes.
for 2 weeks' time to file an affidavit.
5.
Your Lordship, I am appearing on behalf of respondent 1 to 4 and I have
I'm for
You're
5,
for
Your
5.
Lordship.
How much? 2 weeks time?
Yes, Your Lordship.
We'll give you 3 weeks time.
3 weeks time.
Okay, Your Lordship.
Yeah, 3 weeks time as please further of affidavit list thereafter. Even 3 weeks won't be enough.
Like GHDC has no role, my lord.
You have no role.
But let them file their reply, Your Lordship.
Anyway, my lord, since they have prayed for it.
Because there is land dispute also. Your Lord.
15.
But here we have received the affidavit filed by the respondent.
State has filed the
for a
affidavit.
week's time, my lord, to reply. File my rejoinder, my lord.
You need a rejoinder. We can
Yes, my
pull it
lord.
off.
They have alleged, my lord, concealment of facts, my lord. We have to rebut
You can
those.
expect this court to crack its head to go into like no intricacies
Since they have
of
raised
the
that issue,
chemical
my lord.
formula, like given in the medicinal bottle. The other day I asked for medicine. I couldn't read the what's written behind in that medical
Sample,
strip.
yeah.
Yes, Mr. S. Papa, please allow 1 week's time to examine the average 5 respondent to file rejoinder list. Yes.
Hearing 16.
Please, Your Lordship, it's only fixed for the calculation, Your Honor, or how much is it pending, the terminal benefits, Your Lordship. I, in fact, would like to show Your Lordship the calculation according to what I feel is due to me, Your Lordship. Before I do that, Your Lordship, I would like Lordship to show this rule, the Central Civil Service Pension Rule. This will clearly show the calculation.
What he's saying? He's saying only what is the amount due to you? How much is it? Where's Dr. Mozika? He's on court today. We'll have it tomorrow, Mr. Marpan. Tomorrow, day after.
Whatever convenient, Your Lordship.
So we're going to close it, no?
Yes,
we'll close it.
Yes,
Finally,
I'll have to show this.
Ali, Dr. Mozika should be here, but only thing because he's the he's a vital respondent also.
Yes.
Due to the absence of Mr. and Dr. and Mozika, this is a matter day after tomorrow. It's so please come. You just inform your senior that you see the court has expressed that this matter will be disposed of on day after tomorrow. It's gone on long enough.
Yes.
19.
May it please Your Lordship, that it comes at the end of the board, Your Lordship. It'll take some time for hearing, Your Lordship.
You're already at the end of the board. Certainly.
Slightly, sir. Salai.
That's my
You
humble.
ready with the matter?
Yeah, well.
No, we're ready.
Okay, then.
Yes.
Since Mr.
Public.
Malang, he wants to have a lengthy discourse. So.
20.
Yeah. Yes.
Your Lordship, this is regarding that gratuity, Your Lordship.
Where was the Karma plan?
I just saw her. She's on her way, Your Lordship.
No, not MS. Mr. Key. Abraham.
May come at the end of the board, Your Lordship.
We already ended the board. You ready with the matter? The way you're just strolling around. Yes. Start. Call the government council also. Where is he?
Your Lordship, this is regarding the delay in payment of gratuity, Your Lordship, and the ground, and despite the lapse of more than 5 to 6 years, Your Lordship, and the grounds which the respondent have taken is Form 17, Your Lordship, which is
17.
Form 17, Your Lordship.
Where is that?
It's in their affidavit, Your Lordship.
By number 5.
Yes, Your Lordship. Page number 11, Your Lordship. So, Your Lordship, which is irrelevant, Your Lordship, because here the petitioner, he himself
Where's
is
page
alive.
11,
Yes.
lecture 1.
Annexure 1, Your Lordship.
Around 4 and Okay, what do you want to show from here?
Your Lordship, I'm sorry, Your Lordship, is page number 12, Your Lordship. Next page. Annexure 2. Second paragraph, Your Lordship.
Yes. It is
Pension.
Okay.
Yes, Your Lordship, and which is irrelevant, Your Lordship, because the petitioner, he himself is alive, Your Lordship. He himself, he could receive the gratuity, Your Lordship. So asking for family details and all is irrelevant, Your Lordship, in my case.
Yes,
So,
why ask for his wife or not when he's alive?
Page number 4 of my Your Lordship.
It's necessary.
Yes, Your Lordship.
You're not married.
I am married, Your Lordship, but then I have already disclosed in my petition that a divorce was filed, Your Lordship, and it's still pending before the District Council. Yes, Lordship.
Now it's over.
No, Your Lordship, it's still pending, Your Lordship.
Why it's not a mutual consent divorce?
No, Your Lordship.
Your Lordship, page number 4. As per Rule 69 of the MCS Pension Rule 1983, sanctioned drawal and disbursement of provisional pension and gratuity specify that if, for any special reason, it has not been found possible to complete and forward the pension papers to the officer responsible for issuing the pension payment order within the prescribed time scheduled in a particular case, if the pension papers have been sent late to that officer and or that officer has either returned the papers to the head of office for eliciting
I don't understand. Why are you reading this?
Your Lordship, before, if gratuity is yet to be paid to the pensioner, 80% and is 3 gratuity should be paid by the state, Your Lordship, before all the pension papers.
Before the entire thing is settled.
Yes.
Your Lordship, I may allow to be submit. Your Lordship, all these are between the respondents, Your Lordship, and because of this, the petitioner is suffering, and this has to be processed before 1 month of prior to the date of retirement, Your Lordship, and now it's already 5 to 6 years. So
They'll pay interest. Yes, Mr. Abraham, why not paying?
Lordship, we have forwarded this.
No, but then what about this MCS Rule 69, MCS Pension Rule?
Those are the documents which I mean they should not insist, which is not required. This is a one-time payment gratuity. Had it been like pension, different thing, but it's on gratuity. It is one-time payment. It is the AG office.
There is a requirement that now the person's having some personal difficulty in the sense that divorce proceedings are on. So how can he give the name of his person he doesn't want as a wife anymore?
We have already forwarded all the pension paper to the AG office, but it is the AG office who has written back that they need to get this.
Your Lordship, if you look at Rule 63, sanction of ancillary pension and gratuity of the head of office shall authorize under intimation to the ordered officer.
You settle it, you release it, whatever payment payable now.
The money is with them.
Your Lordship.
It is money is with them, and actually it is the AG office who has to pay the.
Who will pay the interest now?
Lordship,
it's the AG office, Your Lordship, gratuity.
Lordship, because the state government have to pay 80% as 3 and this 3 gratuity when pension is yet to be paid, Your Lordship.
And all this final calculation has to be done by the AG office, and they'll be authorized.
No, but one
we
thing,
are
Mr. Abraham, see, the thing is that the reason given by them is not 80%. The reason given by them, as shown by legal counsel in the affidavit, is at page 12.
yes, Your Lordship.
Where's the letter you ask them to process the 80% can be paid, feeling even this.
Your Lordship,
where's the correspondence you've had with the district secretary officer?
Lordship, may kindly turn to page 19, Your Lordship.
Let us see. Okay, take down. Anything else to say?
Your Lordship, from what I'm instructed is the state government have to pay 80% as for now since the DPO order.
Yes. Take down. The petitioner who retired as
Lordship.
he retired as what? He was appointed as sericulture demonstrator.
Yes, supervisor, Your Lordship.
Who retired as a supervisor.
Yes, Your Lordship. Yes, Your Lordship.
In the office of the Director of Sericulture and Weaving, Government of Meghalaya, is before this court with a prayer to direct the respondents to release a gratuity amount as payable from the date of entitlement to the date of actual payment. Stop. MS.A. Kharshi, letter counsel for the petitioner, has submitted that the petitioner had retired after serving for 38 years and was released from service on 31/3/2019. And though terminal benefits such as GPF and leave encashment had been given to the petitioner, the gratuity amount till date still remains to be paid. It is submitted by learned counsel that the reason given by the respondent number 5, Accountant General, for non-processing of the payment of gratuity is due to the fact that the writ petitioner has not intimated in Form 17 the list of family members this is contained. She submits in a letter dated 25/6/2024 from the Senior Accounts Officer, respondent number from the respondent number 5, addressed to the respondent number 4. It is submitted by the counsel that this requirement, in view of the fact that the petitioner is still alive, should not be an impediment to the release of gratuity. She therefore prays that the respondents be directed to process and release the gratuity petitioner at the earliest. Stop. Next paragraph. Ms. H. Abraham, appearing for the response 124. What are you saying?
See, we have given the calculation. This 5 lakhs or 9 lakhs to 7,200 is the tentative calculation. The final calculation will be given by the AG office.
No. What were you saying? What final calculation? What reason for not paying payment? Not bother about
we have already processed this gratuity paper and submitted to the office of the AG. In return, the AG office has asking the document which they are not supposed to ask. They are asking the family Form 17 list of family members.
Ms. H. Abraham, Learned counsels for 1 to 4, for state respondents 1 to 4, submitted that all requirements, including the computation of the amounts due, have been made by the state respondents and submitted to the respondent number 5. But however, the respondent number 5, due to the query with regard to Form 17, has still yet to release the gratuity amount of the petitioner. So, next paragraph. MS EB Pasa, appearing for the respondent number 5, has submitted that, notwithstanding any impediment, as per Rule 69 of the Meghalaya Civil Services Pension Rules 1983, the head of the department, in the event in the delay of submission of pension papers or delay in processing a settlement thereof, an amount of 80%, 80% amount due is to be released by the state respondents. The council has also referred to an office memorandum dated 19/5/2014 annexed to the affidavit respondent number 5. 2019, you retired.
Yes, Your Lordship.
Who will pay the interest? You share 4%.
To the state government, because
Yes.
they have to pay the 80% as well now, Your Lordship.
So you pay interest on 20% and it pay interest on 80%. When they receive the objection with regard to Form 17?
That we received on 28/5/2024.
The first time?
Yeah, they have written the letter.
And then when you start processing the gratuity?
We have already processed much before that, Your Lordship.
Your Lordship,
Can you just give me the dates?
Date exactly. The exact date. The petitioner has signed the pension paper on 28 May 2024. 24 May, that is in paragraph 6 of my affidavit filed by respondent number 3.
Why sign 24 only?
Your Lordship, we have communicated a letter to the District Agriculture Officer on the 25th June, Your Lordship, 2020.
No, when was it processed? After he retired, other term benefits, GPF, then leave encashment, other things. When does pension commence from?
Your Lordship, I may submit, Your Lordship. Actually, his leave encashment and GPF, you have already
yes,
received,
already taken it. Yes.
Yes,
When was it that paid?
It was, Your Lordship may... May kindly turn to page 6, Your Lordship, of my petition. Lordship, I may read, Your Lordship.
Yes.
That in pursuance to the retirement from service on 31st 3/2019, respondent number 4, that is the District Agriculture Officer, Ribhoi District, Nongpa, has directed the petitioner, write letter so-and-so, dated 5th September 2019, to visit the respondent office and sign the pension paper and to submit along with the birth certificate of his wife and his children and joint family photograph in order to prepare the pension PPO order. Your Lordship, I think they had We have not
See,
mentioned.
2019, that time we given your picture, your wife and everything.
No, Your Lordship. I beg your pardon, Your Lordship.
2019, given all the particulars.
We have, Your Lordship, we went to sign the pension paper, Your Lordship. But then the respondent, they asked us to produce the birth certificate and all the documents, Your Lordship.
This you didn't give.
No, Your Lordship.
Then we'll withhold interest then.
Your Lordship, because the thing is, they have filed a divorce, Your Lordship.
That from the time before he retired.
Yes, Your Lordship. So we are unable to produce, Your Lordship.
Your Lordship, if not the marriage certificate, but the birth certificate of his children, Your Lordship.
The status of children, you have children.
Children is staying with the wife, Your Lordship.
Doesn't matter, they'll be entitled. Are they major or minor?
Uh,
They will be major by now.
yes, Your Lordship.
Strange case because they asked it from 2019 to come with the papers. So,
And they come and sign only on 28 May 2024 pension paper, yes.
Oh no, they were asked to come on 19, right?
They come, but they did not sign the pension paper. The pension paper was signed only on 28 May 2024, Your Lordship.
Strange case, yes. Problem. Yes. What is letter annexure 5, page 24 of your petition?
Your Lordship, this one also, they have asked us to produce the documents only, Your Lordship. Photographs and all.
Now, in 22 also reminded you. What stage is the divorce proceeding?
Evidence, Your Lordship.
The thing is that now you don't have children. How many children do you have? Should have given those details.
If I'm pleased to take Your Lordship to NHO 1, page 6 of my affidavit filed by the respondent. They have nominated, he has nominated his daughter 50% and niece 50% in his pension paper, yes, Lordship. If I'm pleased to take Your Lordship to page 6.
Your affidavit?
Yes, in my affidavit filed by the respondent number 3, Your Lordship. The last 3 lines.
Your Lordship, this will come into effect only after his death, Your Lordship. When he's like very much alive, so he can receive by himself, Your Lordship.
Yes.
And all this are.
No. But one thing is it's a statutory requirement that you give that Form 17.
Yes, Your Lordship.
Statutory requirement.
Yes, Your Lordship. In the event of this, that Your Lordship, there are some certain circumstances, Your Lordship, 2-3 wives will come and claim a pension, Your Lordship. It will put us in a very difficult position.
Your Lordship, that is with regards to pension, Your Lordship, family pension. Mine is only gratuity, Your Lordship.
Yes, Your Lordship, for us to process the gratuity, everything.
Because the thing is, the process involves all together. You understand? Like they process once for all to get your PPO also. Like your gratuity amounts, how much is going to put in, what will be your monthly pension, that will be in one shot, they'll give it all to you. According to leave encashment, everything you calculated, then the state government will pay you. That's what is done. The thing is that you're trying to separate your pension, which might be contested later on, from gratuity, which you want to receive right now. So you take 80%, 20%, you wait outcome of your divorce proceedings. What is Mr. Majab? Correct. It's all right. What about interest? Because we can't pin the blame squarely on. There are many letters that said, please.
Let them release a full gratuity amount, Lordship, with all interest, Lordship.
Your Lordship,
We are fine with that, Lordship.
Then with regard to the pension component, for non-supply of the nominee.
For that reason, Your Lordship, we came only for gratuity, Your Lordship, because the divorce still pending, Your Lordship.
Okay, yes, take down. Hamna? Wait, to Abraham, for that Abraham, which Abraham submits what? The mirror prepared of the case. So you should give all the facts to the court. Yes. Has been made. Stop. It is further submitted by learned counsel that this query is with regard to the supply of the names of the family members who are to be the retired employees nominees, which in spite of several reminders was not provided by the writ petitioner. He therefore submits that since this was this deadlock, the entire matter has stood delayed. So, the next submission EB was ends how? Memorandums also 80%. Sorry. Eighty percent of the amount for the affidavit. 80% of the gratuity payable is to be released by the state government. I have heard the counsel of the parties and examined the materials on record. From the submissions, what emerges is that the petitioner, who had retired in 2019, though allowed the other terminal benefits and pension, leave encashment, etc., yes, is yet to receive gratuity on account of the fact that he has not furnished the names of the nominees with regard to his pension. Stop. From the petition itself, it can be seen that several reminders have been issued to the petitioner to comply with the needful. But however, as it appears from submissions of the petitioner that the same could be furnished due to the fact, due to account of ongoing divorce proceedings, the payment of gratuity has since been held up. So, next paragraph. Gratuity is a right of a retired employee, and in instant case, what is seen is the delay has been caused due to the non-furnishing of the name of his wife. Wife, is that? Family members of the petitioner. Stop. However, referring to the memorandum dated 19/5/2014, at least release of at least 80% gratuity should not have been an impediment to the state respondents, inasmuch as it is not a case where the retired employee has expired. The set of memorandum for the sake of convenience, is reproduced here and below. As the matter, in the backdrop of these facts, therefore, though some doubts may remain with regard to the exact nominees to avail of family pension in the event of the petitioner's demise, with regard to gratuity, as he is still, with regard to gratuity, this court directs that 100% thereof shall be released by the respondents to the writ petitioner within a period of
1 month, Your Lordship.
within a
1
period
month.
of
3 months, Your
within a
Lordship.
period of 2 months. Okay, within a period of 2 months time. The other terminal benefits, the other terminal benefits such as pension, etc., for which the writ petitioner has not furnished proper nominations, the respondent number 5 shall be at liberty to take appropriate steps in that regard. So, we won't give you interest. We give interest.
This part of the delay has been caused by the petitioner, Your Lordship.
As the actions of the respondents seem to be bona fide, no interest will be awarded on the amount of full gratuity. Matters on stands closed. Disposal.
Much obliged, Your Lordship.
22.
Yes.
Please, my lords. Well, this is the matter concerning the lab technicians, and they were confirmed, and subsequently, my lords.
Very matter.
Your Lordship, Mr. Shulai is leading the matter, Your Lordship, and he's on legs.
He has some difficulty, my lords. He had to be in courtroom number 1, my lords. So expressed, my lords, his difficulty. Today.
Your Lordship, he'll be advancing the arguments, Your Lordship.
We could have it sometime next week, my lords, subject to your Lordship's kind convenience.
Okay.
Only, my lords, I have a small prayer. My lords, we had earlier said that we'll not file a rejoinder because that was not necessary. We'll file an additional affidavit, my lords, bringing one of the notifications of the government, my lords, which will have a bearing in this matter.
You want to file an affidavit?
My lords, it's a notification of the finance department which gives concurrence to this confirmation.
Mr. K. Paul today praised him allowed to file to bring on record a notification
of the finance department, government of Meghalaya,
which is relevant to the matter by additional affidavit. Praise allowed. This is matter after 2 weeks. Yes.
May I pray after next week, my lords?
Why some urgency?
There's some urgency, my
After
lords.
1 week, yes.
My lords.
Obliged, Your Lordship.
23.
Your Lordship, 22 to 26 are connected.
These are connected matters.
27.
May it please, Your Lordships.
Yes.
My lord, this is a case, my lord. This is a covered case. Our contention. This is pertaining to the settlement of an waivage.
My lord,
Oh,
if,
no,
I,
not that case.
if I may just interject, my
What
lord.
happened to that? What you said that has been dismissed.
SLP. This is still pending. No order has been passed.
No,
So far, I have no knowledge.
I see your indulgence, my lord. Can you grant me some time, my lord, to file an additional affidavit to bring on record the order of the Supreme Court, my lord, with regards to
order
this
is
case? Because the moot point out here is, my lord, is that whether the agreement signed by the commissioner is valid, my lord. And a similar case has been filed before this honorable court, my lord. Same issue, my lord. And that issue is before we had to file an appeal before the Supreme Court, my lord. So, my lord, with your permissions, we would like to bring on record, my lord, the order of the Supreme Court, which will have a bearing, my lord. Lordship?
What order is it there with you?
No, my lord. We'll file
What is this order? To
Can
my
you grant
knowledge,
me some-
no, my,
1 week. Yes.
no, my lord. Only thing, my lord. Otherwise, my license will expire, my lord.
Why
May.
expire? It's already a death letter that you're coming again.
No, no, my lord. Clearly situated.
1 week
cannot
time
be
allowed to the state respondent to file an affidavit being record copy of Supreme Court order which is relevant to the matter.
My knowledge, my lord, nothing has been passed.
You should have come with the order. No, what was the last order, Mr. Sen?
No, my lord, no notice has been served on us. There is nothing, in fact. I don't know what they are saying. My lord. Just delaying the matter and making it infractuous, my lord. That should not happen.
Yes.
19.
Now we enter the board.
Highly obliged for that. May it please your lordship, just to summarize the petition been filed by the petitioner, your lordship.
Okay.
In para 3, your lordship, of the writ petition, page 8, your lordship.
Para 3?
Yes, page 8, your lordship, para 3.
Yes.
The petitioner was appointed as an assistant administrative officer way back in the year 1983. Copy of the office order also has already been annexed. Thereafter, he was promoted on many occasions, and finally, when he had reached the age of superannuation, he was appointed in Bhubaneswar as a CRM, or we call Chief Regional Manager, which that also has been annexed in the Annexure 2, your lordship.
So he reached a very high post.
Yes, your lordship. From a very lower rung, your lordship. Lower rung, up to the higher rung.
Yes.
Yes. Thereafter,
He retired when?
31/7/2015, your lordship. 2015, 1/5. Yes. Annexure 2. Thereafter, the moment he had reaches his age of superannuation, then he also filed the application. He had filed the. Then he had submitted all the relevant documents before the competent authority. Why? So as to get my pensionary benefits. That is the normal procedure. It has to be done, your lordship.
Okay, then what happened?
But thereafter, unfortunately, in the para 4 which has been mentioned, however, the petitioner with utter shock and surprise came to learn that his gratuity and the commutation of fraction of the pension, which the petitioner legally entitled, not been released by the respondents. I mean, I'm talking about the Oriental respondents, your lordship. That is Annexure 3. Thereafter, your lordship, since they have not released the pensionary benefits, including the gratuity as well as a fraction of the pension, I filed a representation. That also I filed before the competent authority. Then we call the chief. We called him as a CMD, your lordship. Chairman come managing director, your lordship. That was reflected in the Annexure 4 and 5, page 37 and 40 of the petition, your lordship. 6, again, which has already been reiterating, your lordship, in para 6, the petitioner most respectfully submits that after rendering service for nearly 32 years, your lordship, that means at the time when I was appointed, then till the age of superannuation, that means 32 years in the service, your lordship, out of which 21 years he has rendered his service in the state of Meghalaya. Then finally he's been promoted to the higher rung post again and again. In short, CRM we call it, or Chief Regional Manager in Bhubaneswar, your lordship. It's already been reflected in this biodata also. Annexure 6.
Yes.
Then, what is important now, it's coming to a very important point, your lordship. Para 7. Since there's no reply of the of the representation, Your Lordship, there's no option except he has to come by way of writ before this Honorable High Court, Your Lordship. It's been registered as WPC number 20 of 2016. With a small direction that the respondent should release all the pension benefits, including the gratuity and the fraction of the pension, along with the interest from the date of superannuation. But Para 8 is also very important, Your Lordship. But surprisingly, the petitioner, after receiving the copy of the affidavit in opposition, after receiving, Your Lordship, the filed by the Oriental Insurance respondents, when it was stated inter alia that there is a CBI case, there's a CBI case in the court of CBI Court, Bhubaneswar.
Yes.
Yeah. Under different sections of the IPC as well as the PCA Act, Your Lordship. However, Your Lordship, till the age of superannuation also, that is on 31/7/2015, the petitioner was not aware, of the said proceeding. Yes, Your Lordship.
No, if I was being filed against him.
Yes, I was never aware of all that, Your Lordship. It was only at the time when they filed the counter affidavit, Your Lordship, in the previous writ petition, Your Lordship. But nevertheless, Your Lordship, he withdrew the writ petition and white order dated 25/2/2021. This Honorable Court was pleased to allow the petitioner to pursue other cause of action, which have been reflected in the order passed by this Honorable Court, Annexure 7.
Yes.
Yeah, page 42. However, Your Lordship, he was very keen to pursue in that CBI case. Until now also he is pursuing, Your Lordship. But due to the delay for almost assuming from the date of 2015, more than 8 years,
yes,
nothing had happened till now. Or what to say, the criminal proceeding is still pending, Your Lordship. So because of that, there's no other option. We have filed one representation before the competent authorities, which all been mentioned in Annexure 9, Your Lordship.
Yes.
Unfortunately, the respondents also did not take heed of my representation. Because of that, I have to come back before this Honorable Court, Your Lordship. What is important is very important, Your Lordship. At Para 9, I'm talking about whatever CBI case. Of course, this is not important in this instant case, but still, just to bring on record, Your Lordship. That's why I've already filed, we've already won Para 9 of the writ. What it says, Your Lordship, that due to the delay for more than 3 years from the date of disposal, and this was under the assumption that the criminal proceeding would be disposed of, and accordingly the petitioner would be getting. I would like it because I'm ready for all that, because whatever allegation made have not been, they're all unfounded.
Special case in
Yes, Your Lordship.
What is the stage?
Till now, trial. There's no stage where we do not.
How many accused are there?
Yes, Your Lord. No, accused is in Shillong.
No, how many accused are there in that?
There's so about. I have.
What's the stage of the case?
The stage of the case, in fact, that the CBI case is pending.
That's all only.
Pending, yes.
What's still pending?
Stage of the case so far, they have annexed the documents regarding mentioning the stage till last.
So to release a pension, you need vigilance clearance.
Yes, madam. I have categorically mentioned in my, because vigilance is pending. The Central Vigilance Committee has categorically.
No, your vigilance from your own is internal vigilance, correct?
But it's internal vigilance.
It's not consequent upon CBI proceedings.
This is not exactly consequent of all this.
Yes, Your Lord.
But so far, gratuity is concerned, since the Central Vigilance Committee has mentioned categorically that gratuity is not to be paid. Whereas again, there is also a circular in which he has opted. Let him finish his submission, I'll make my submission.
We will cut things short. The thing is that it's not been paid his pension and other term benefits because of the CBI case. So what under what rules is he bound?
Malat,
I mean, under what rules is he bound? That
so far, Malat,
they are relying on the circular, Your Lordship.
So far the
circular has the force of law, only guidance.
Yes.
Malat,
It doesn't have the force of law.
Malat, so
which
far
is in
circular
violation of
concerned-
Article 300A, Your Lordship, of the Constitution.
So far circular is concerned, it is a standing order. But so far the payment of pension is concerned, the employees are governed by the General Insurance Employee Scheme 1985. I have a copy of that.
It bars payment
Yes,
of pension
yes, yes,
when a person has criminal proceedings
It
against
bars.
him. Where's that?
It bars.
Show me the rules. Where's the copy of the rules? You have provided?
I have a copy. 46. Rule 46. 46.
He has a copy of the rules also?
No, Your Lordship.
Then you give a copy of the rule 46.
Yeah.
No copy has been served to me, Your Lordship.
This commutation is not for regular pension.
Malat.
This is for commutation of pension.
Yes, so far.
So commutation pension, you see, if he takes
Yes,
it all out, that
they are-
means
they are
that
claiming for
recovery
commutation pension.
will be difficult.
Yes.
That's for commutation. You ask for commutation.
Yes,
Yes.
Your Lord, we have.
Then you'll not be eligible.
Yes. Then
you
again,
give a copy of this one.
Yes,
No, I don't have it. There's no
Give a
copy.
copy of the rules.
Yes.
See, Mr. Walang, he is saying that under this General Insurance Employees Pension Scheme 1995,
Yes,
correct?
after-
So you applied for commutation under this scheme, correct?
Yes, Your Lordship.
And he says that because criminal proceedings are pending against you, then you'll not be entitled to commutation of pension under this scheme. That's all.
No, Your Lordship. Let me just
No,
draw
no,
your...
but then the rule says that.
No, it's there. I'm not for it.
You got the rule.
I don't have, Your Lordship.
Then you get the rules. How you give a copy?
Yes.
We'll have it again.
It's fixed another date, Your Lordship.
Yes, in the course of hearing, Mr. Ayub Khan has submitted that the non-commutation, the pension, the petitioner is as per the General Insurance Bracket Employees Pension Scheme 1995. Mr. S. Walang, please allow to peruse the same and prepare the case further. Yes.
Yes.
Matters shall stand over to when? Give a date. Up to you.
Up to 2 weeks.
Yeah. You take the date. Yes.
Yes.
Feel at liberty. Yes. You still take a long time. It's a small matter.
No, actually, because there's so many other things I'd like to bring before this honorable court, Your Lordship.
Yes.
They're relying on the circular which doesn't have the force of law, which we've already admitted, Your Lordship. Already admitted.
No, that's what, see, it might not have the power of the
Already
guidelines,
admitted.
but the thing is that general insurance scheme, under pension scheme,
They're
which you
governed by
opted
that.
under,
So far the pension
it
is
forbids
covered.
that.
It's covered by that.
That's right.
You see that, you give him a copy.
Let me just get the copy. Yes.
Supplementary list
Rule
item number
46,
1.
yes.
Highly obliged, chiefs.
My lord, this is a transfer petition.
Why ask unlisted?
My lord, this matter is coming up tomorrow, my lord. We are apprehensive that final orders be passed tomorrow.
What's the next one? What do you mean by marriage certificate is not in your index? The certificate can be married also.
That is, I'm so sorry, my lord. That's a typographical error. I'm sorry for this.
It's all right.
No, my lord. What has
Expect
happened?
more from MS Mauri. You drafted the petition. Okay. Yes.
My lord, what has happened here is, by my lord's order, which is set in Annexure 6, my lord was pleased to direct the CEM to hear the appeal after proper parties are arrayed. My lord, the contention of the writ petitioner before my lords in WPC number 457 of 2009
You didn't
was
serve
that.
to standing council?
No, my lord. This is
Then?
The GHDC will not be necessary, my lord. It's a transfer petition, my lord. It's a matter pending before in the court of CEM. So,
Is that a court? CM is a quasi-judicial authority.
my lord, in this matter, my lord, as per the
You have
validating
to array
act,
them
my
as
lord,
parties.
I have arrayed the other.
As far as validating authority, you can't.
So he
Civil
exercised-
court decisions barred.
Yes.
Section 11. Yes, so you can't. Yes.
So, my lord, what happened was that my lord has directed to adjudicate the appeal after airing the proper parties. Now, my lord, this order was misread and misconstrued, and then the the court of the CEM treated this as an order directing to hear the appeal afresh. Not only that, my lord.
Where's the direction? Just
my lord will kindly come to Annexure 6, page 26.
yes.
In turn, the relevant paragraph will be paragraph 9, which is at page 30, my lord.
Yes.
I'll just read it, my lord. However, looking into the facts and circumstances of the case, it appears that the writ petitioners were, as per submissions of Sri So-and-so, counsel for the petition, on a wrong assumption that an appeal would be maintainable even if it is preferred by their clan members. In this context, therefore, taking a liberal view, considering the nature of the case, and by applications of the principles of equity in justice, coupled with the fact that the writ petitioner will be rendered remediless, liberty is given to the writ petitioner to prefer fresh appeal against the impugned order before the CEM, who will decide the same in accordance with law. Needless to add, the issue of delay and explanation thereof shall also be considered by the CEM. Now, my lord, there was a delay in this, so thereafter they filed an application for condonation of the delay. This application was disposed by an order dated 19/10/2022, that is Annexure 8, page 40 of the writ petition, my lord.
Yes.
My lord will kindly see the order, the first paragraph, that this miss case is in connection with the High Court remand case, wherein the Honorable High Court, by its order dated 11/5/2022, has directed this court for fresh trial. My lord, the court of CEM is an appellate court, my lord. So, my lord, so they have misconstrued, misinterpreted my lord's order, and then they have treated this as a case for fresh trial, and the appellate court itself has taken evidence in this case. Now, my lord, what we have come to learn later is that even before the appeal was registered, my lord, even before the orders in the condonation application was filed, the CEM himself has written to the district collector, South Garo Hills, not to release the compensation money, because
that is the main point.
That is the crux of the matter, my lord. And my lord will kindly come to Annexure 9 and Annexure 10 and Annexure 9, my lord, and Annexure 11. My lord, he is a signatory to this. Sir,
where to transfer it to?
My lord, this court is empowered to transfer it to the district court, my lord. It can be transferred because, my lord,
matter. Statutory bar is there.
My lord, the provision is there, my lord. My lord, this is the High Court of Meghalaya jurisdiction over District Council's order 2014. Order 7. I'll just read Order 7, my lord. Whenever it is made to appear to the High Court that the fair and impartial trial, inquiry, or adjudication.
This is not a court. No, this is the CEM. It's executive function.
My lord,
that's why I'm saying quasi-judicial. We don't have the power to transfer for you.
In fact, my lord, the administration of justice,
The only thing for you to do is you can't file a transfer petition, not be maintainable. The thing is that you have to challenge the order. I mean, like the proceedings.
My lord, my lord, here it says that that it can be transferred, my lord. It can be transferred to the from any court in the district council to any other court, my lord. 7
It's not
provides.
a court. This is a quasi-judicial. It's CM. My lord, Gautam please try to understand.
Yes, my lord.
If it's under this 14 rules, high court decision, fine. It's appendix 13, right? But this does not come. Will not come under this. Will not come under the just.
What is that?
Will not come.
My lord, insofar as NOCMA matters are concerned, my lord, the Validating Act empowers the court of the CEM to act as a court, my lord.
See,
to act as a proper
Social
civil court.
Validating Act says what? Even we're looking at Section 11 bars civil court jurisdiction. So that whole jurisdiction of High Court over the Council Act goes out. Now the only thing is that asking for transfer to which court? We can't transfer executive matter from CEM of Garo Hills to CEM of Jayante Hills. We can't do that.
My lord, I'll satisfy my lords on this point, my lord.
Tomorrow. We can't. Otherwise, you withdraw it and file a different petition. I will not advise you, but yes, sir.
My lord, the matter is coming up tomorrow, my lord.
You take adjournment. See, you file in the thing.
My lord, the way
see that you
the
file
manner
an
in which
application for the High Court.
My lord, the manner in which the matter is proceeding there.
The more illegal the matter becomes, easier it is for you to assail it. Remember that.
Lord, the moment the order is passed, this money is going to be released. That is the whole issue, my lord.
Tomorrow,
my lord, tomorrow I'll make an attempt to satisfy my lord.
Just tomorrow.
Yes. Obliged.